some research in the Grand Island public school systems on what might look best. They looked all across the United States. One of the things they found most effective in one of the places that they looked at was the partnership between the county attorney's office and the schools. And the research that they did is how they developed this program. I came in after that research, so I'm not going to spend a lot of time on how it got developed, but I'll tell you I really like the concept in this particular relationship, and I'll show you why as I talk. It's a partnership with the county attorney's office. And we got in LD, it was in 800, yep. They put the language in there that helped us a little bit because we've got some FERPA laws that we have to be careful of. And FERPA does say that if there's a state law, and I'm paraphrasing, I don't have the exact quote for you, but FERPA says if there are state laws out there that allow the dissemination of knowledge, of information, of student information at the state level, then you can do that. It's an exception to the FERPA law. FERPA is very protective of student information on a federal level. But the federal government, the law says if you've got a state law that tells you that you can give this information away for a valid reason, then you can do so. We in Hall County believe that the addition at the end of this, and I've got it here somewhere, 79209, nothing in this section shall preclude a county attorney from being involved at any stage in the process to address excessive absenteeism. So that's a nod to the fact that the county attorney, oh, sorry, I think got that on the slide too. That's a nod to the fact that if the county attorney wants to get involved, they can, and I think they should be on board with the schools, because at the school level, when you're finding a bunch of absences, and I don't deal with truancy, I use absences, excessive absenteeism. They changed the law. There's only like 2 references to truancy anymore. We title these things wrong now going forward. It's excessive absences for whatever reason. But we deal with excessive absences, and if you have excessive absences, the next step, if you can't address it at the school level, is the referral to the county attorney's office. So in our system, what we do in Grand Island, it makes perfect sense because the next step is my office. Now we have the 10% rule. The state law tells us it should miss no more than 5 days per quarter or the hourly equivalent. A quarter has about 50 days in it, 10%. So 10% is our trigger. The kid gets up at about 10% and then continues at that level, we're intervening. We in Grand Island are fortunate, we have social workers. However, I'm a Hall County deputy Hall County attorney. So I deal with Wood River and I deal with Donovan. I just had a couple Wood River folks in my office. They don't have the social worker, but they do have somebody identified at their school that monitors attendance and starts intervening with these kids and these families. And they do it pretty early. And 10% is, if it gets to 10%, that's the highest it should go, in my opinion. And the schools bear this out before we're intervening with these kids. Or these parents, depending on the age of the kid. And that's based on the statute, 5 absences per quarter or the hourly equivalent. Okay? So we get social worker contact with the family in Grand Island Public School System. Some school contact with the family saying, hey, we're concerned, here's the state laws. We always bring it back to the fact that studies show that when kids miss a ton of school, they fall behind. Now in ours we do a first letter that has my signature on it within the Grand Island Public School System saying, hey, we're noticing a problem. Please work with your school to address this problem. We then send out a second letter. It's got it's bold second notice, try to get their attention. All right, you've continued to have some problems. Go see your social worker. And then we have the optional step with us to come into an attendance hearing. And we've developed some language that our attendance hearings, it's much like the juvenile diversion, is the way I liken it. You've got an opportunity to come in and have this discussion with the school, with the parents and the student, in front of me, the deputy county attorney, at the school, not at my office at the county attorney. And I point left because when I'm sitting there in my room, my county attorney's office is left. Okay. And I tell them this is like diversion. I say it every single time. This is like your chance at diversion here. You do not have to come into this room, and if they're in there, you don't have to stay here. However, your kid is missing a lot of school, or you, student, are missing a lot of school, and this has to change. There's a lot of real good reasons why it has to change, but it does have to change. Work with us here, in this setting, in this hearing, and we'll work with you to keep you out of the county court system. We don't want them in the juvenile justice system. So we bring them in for an attendance hearing. We send them out a summons, much like a court summons, saying, please be here. We usually give them a couple weeks notice to get them there. We'll do it as soon as a week. If the problem really flares up, we'll bring them in sooner. And that's the nice part about school. Being a deputy county attorney, you can't do anything without 2 or 3 weeks notice in a courtroom. The nice part about schools is they don't have any problem bringing the parent in tomorrow. I kind of like that. So we have our initial attendance hearing. It's like a mini trial. On the left is the school, and I asked them to present the evidence, present the reasons why we're here. Why is the school concerned about this kid's attendance? To the right is mom, dad, combination of those two, and for the 6th through 8th graders, the student will be there too. We typically do not have K through 5 there, sitting at the table. The school will present their evidence, then I give the parents a chance to respond, and then we focus on what can we do from this point forward to try to solve this problem. We do our best to identify whatever problem. What are the concerns? Why are we missing school? You missed school, okay. Why are you missing school? What can we do going forward? And is there anything the school can be doing to help out? In the diversion part of this, we are trying to be as collaborative as possible. And I always make me the bad guy in that situation and let the school be the good guy, willing to help. Because we've got to have the schools not adversarial. And I think that part of the unique nature of our program is the county attorney's up there banging his fist saying, you got to do this. And the county attorney, that deputy county attorney goes a long way because that's the guy that actually can make things happen at county court. So I can be the bad guy, so to speak. We'll let the schools stay in the role as the people that are willing to help out. So we try to come up with a plan of action, what we're going to see, and then we come back for a follow-up hearing, and as many follow-up hearings as we deem necessary to keep them. We don't ever expect that the attendance is just going to skyrocket and go great, but if we can get some improvement, gradual improvement, that's what we're expecting. If we can't, then we do refer to the county attorney's office. So we then bring them in and we ask them to figure out what we need to do, if there's anything the school can do to help them out. We make it imperative, we make them understand it's imperative that the child go to school for a variety of reasons, most importantly for the sake of the child's education, also because of school rules. There's some reasons why we can do what we can do, and I cited 79-209 along the county attorney. 79-201 through 209 gives us our state laws with regard to 5 absences per quarter or the hourly equivalent. That hourly equivalent, comma, or the hourly equivalent is where I loop my tardiness into. We have taken kids to court for tardiness issues only, and our judges have supported us. We don't do it very often. We only do it when it's like an hour, 16 to 20 times and missed in the first hour of the day. But that hourly equivalent is a pretty big little catch-all, and I'm glad we've got it. And that's in 79-201 through 209. 43-247, 3B is the habitually truant. This is the only place I can find where you see the word truant, habitually truant in school. However, truancy is not defined in the statute. So, what I tell them and what I've heard my judges say in my jurisdiction, habitually truant, well, what do you expect? It means anytime you're not at school when you're otherwise supposed to be. I use my second set of statutes there, the 3Bs. Those are when it's the kid issue, more so. And this is 6th, 7th, and 8th graders. 9th grade, we have a little bit of a 9th grade segment as well. That's the 3B. That's where we say this is a kid issue. You got to be there. Not, this is, and that covers anytime you're not supposed to be there. My judges have defined anytime you're supposed to be there. When you're not there when you're always supposed to be. Parties, skipping classes, skipping out on lunch, not coming back from lunch. It's pretty encompassing. It can work. Here's another little bit of statutes, and this is relevant for the juvenile court setting. And my next slide, I'm going to go to that one real quick first. What are the benefits? Is this connection. The benefit that we have, and any of us are going to have in fighting this attendance issue, is connecting with one another. Okay? The juvenile court system, schools, county attorney's office, the probation, diversion, county attorney's office, the office of juvenile services, medical providers. Okay, they're outlined in this previous law that I show you here, 43-3001, Nebraska. This gives us authorization to share information. Again, this overcomes the FERPA privacy requirements that we have.